Assalamualaikum warahmatullahi wabarakatuh. My name is Dalili Fema binti Zaid, matrix number 1200690 from KMB5. And today, I will do a presentation on the rights of the parties in the repossession of goods under Hire Purchase Act 1967. Okay, so first let's look at the objectives of the study. In this study, we look at the rights of the parties involved in the repossession of the goods, which are the owner and the hirer. For instance, the owner is aware of his or her right to reclaim custody of the goods, and the hirer is also aware of their rights in this regard. Before I go further to the explanation, this is the rights of the parties in the repossession of goods under Hire Purchase Act 1967. They have four sections used, which is 16, 17, 18, and 19. So let's look at the first section. Section 16, notice to be given to hirer when goods repose. 16A, hirer who returns goods not liable to pay costs of repossession. So the explanation is, the owner has no right in taking possession of the goods if there are no breach of the contracts or agreements. And the second one, no breach of contract should happen relating to payments of installment unless the payment of installment amounts did not reach 75% of the total cash price of the goods comprised in the hire purchase agreement. Then, if there are two successive defaults of payments by the hirer, the owner shall give notice, and the owner can act if there is no action taken after the 21 days of the notice. When the hirer returns the goods comprised in hire purchase agreement within 21 days after the notice, the hirer is irresponsible in paying the cost of a repossession, the costs related to taking possession, and the cost of storage. For example, Abdullah rents a car from Aiman, which is here Aiman is the owner and Abdullah is the hirer, and they enters a hire purchase agreement. Then Aiman gives notice and claim Abdullah had defaulted on his payments. So the first thing Aiman needs to do is to give notice, and if after 21 days of the notice no action is taken by Abdullah, then Aiman can take action as the owner. Okay, next, let's look at the second section, which is section 17, owner to retain possession of goods reposed for 21 days. Based on section 17, the owner must not sell or dispose the goods after repossession within 21 days. Other than that, if notice have been given to the hirer, the owner must wait until the end of the date in the notice given to sell or dispose of the goods. If the owner default and sell or dispose the goods before the right time, the owner shall be guilty of an offence under this act. For example, after Abdullah enters into hire purchase agreement with Aiman, and at one time Aiman reposes the goods with some factors, Aiman must not sell or dispose the goods within 21 days of repossession. And then section 18, hirer's right and immunities when goods repose. The explanation, when an owner takes possession of any goods under section 16, the hirer can give notice or a written statement signed by the hirer or agent to clarify the status of the goods after 21 days of the notice. Next, the hirer can demand the owner to redeliver or return the goods under the provisions of section 19. Most importantly, the hirer also can require the owner to sell the goods to someone introduced by the hirer who has prepared to buy the goods cash at the price, but the amount must not be less than the estimated value stated in the first notice. So here we can see that it is the hirer's right and immunities when goods are reposed. So for example here, one of the hirer's right after the repossession of the goods is Abdullah can demand Aiman to sell the goods to someone he knows, and his friends are ready to buy the goods in cash, but the amount paid must not be more than the value in the first place. And the last section, section 19, power of hirer to regain possession of goods in certain circumstances. Based on section 19, When the owner reposes the goods, the hirer has the power to regain the rights of the goods within 21 days after giving notice to the owner, but with a certain situation only. The hirer can regain possession of goods when the hirer pays any amount that needed to be paid in the period to the owner. Next, if the owner claims that the hirer breached the contract, the hirer can correct whatever default of the agreement, such as pay costs or any expenses that needed to be paid by the owner. Then, the owner must return the goods to the hirer back according to the agreement requirement as if there were no breach of contract at all. However, Section 19(2) provides that when the goods are returned to the hirer and there are no remedies any breach of agreement, the owner has no rights in arising question about the repossession of the goods unless the owner specifies the breach in the notice given to the hirer. For example, after the repossession of the goods by the owner, who is Aiman, because of some reason such as lack of installment payments, Aiman can give back the goods to Abdullah when Abdullah pays back all the installment due. Then, after all the repayment of all installment due, Abdullah can demand the redelivery of the goods, but Abdullah should give notice and clarify the status of the goods after the redelivery. In the conclusion, the owner knows when they can reclaim control of the item rather than taking it at random. Additionally, the hirer may request that the goods be redelivered once the owner has recovered the goods. Therefore, if they are aware of this matter, there will be no issue or conflict that will result in a legal case. I think that's all for my presentation. I hope you can understand from my explanation. Thank you for listening. Assalamualaikum warahmatullahi wabarakatuh.